Hello everybody. In today's video, we are going to work through a legal contracts problem question using IRAC. This is a basic question. We're going to look at it as if it's a tutorial question rather than an assignment, noting that this will impact your referencing and the types of language that you might use. But the purpose of this video is to show you how you can use IRAC when responding to either a tutorial question in law or a case study or assignment question. So we have this question on the screen. I've called it question 1. We know that View contractors contact a specialised roofing subcontractor, Classie's Roofs, to obtain a quote for the design, manufacture and installation of a unique bronze roof covering for a new prestigious court building in Adelaide. From this first part of the problem question, we know that we are in Adelaide, which means we are in South Australia. So what you might like to do is add a comment, South Australian legislation. Doing this sort of thing as you go, either on a scrap piece of paper or in your Word document, will ensure that you pick up on those key pieces of information that have been provided in the problem question, and they've been provided for a reason, and that's so that you pick up on them. Then on the 12th of June 2013, so we're going to highlight this. I like to use color coding, so all dates for me might be in blue, for example. Classie's Roofs submits a fixed price lump sum quote of $5.2 million by Curia. So that is very important. So we're going to highlight that as well. Classie's Roofs quote contains the following clause. This quote remains valid for up to 6 months from the date of the quote. That's important. This quote includes the provision of a performance bond of up to 5% of the quoted sum. Also important. During the 5 months following Classie's Roofs quote, so that again, we have a date here that's important. So we're just going to we'll highlight the date, very important. Following the quote, the raw material price of bronze escalates by 70% due to unusually strong international demand for bronze. Concerned that their quote is now too low, Classie's Roofs sends a letter to View on the 28th of November. So here we have the 28th of November, highlight that, stating, due to a change in the market conditions for the supply of raw materials, we advise that our quote for bronze roofing, dated the 12th of June 2013, is revoked with immediate effect. So here we're going to highlight that because that is important. This letter arrives at View's office the next day on the 29th of November. Again, we have a date here, so we're going to highlight the date. Then on the 27th of November, View had mailed a letter to Classie's Roofing. So we need to highlight this. And the reason that we highlight dates is sometimes in an example or a problem question, it won't necessarily be in chronological order provided to you. So here we can see that on the 27th, well, we know that's before the 29th. So this here has happened before the letter arrived. This is why it's important to do a bit of a timeline. So the letter to Classie's Roofs states, we are pleased to accept your quote for bronze roofing dated 12th of June 2013, subject to you increasing the value of the performance bond to cover up to 10% of the quoted sum. So now we know that the quoted sum might be a factor that's discussed. So we're going to highlight that. It might not, but it might be. So we're going to highlight it. View's letter arrived at Classie's Roof offices on the 29th of November. So again, we have a date, we're going to highlight it. View is insisting that a binding contract now exists. So that's important. Who is saying what? However, Classie's Roofs denies the existence of the contract. Here we're having a bit of a dispute. Advise whether a legally binding contract exists between View and Classie's Roofs. I've highlighted this in red because this is the actual part of the question that you are responding to. All of this is background information that's really important. However, this here in red shows what the marker is going to be looking for you to answer using your problem solving skills. So what I've done now is I've created a timeline, which we can see here. This is something that you could do on your cheat sheet or in a Microsoft Word document or on just a random piece of paper. It's not part of your answer, so you don't want it to use your word count if this is an assignment. This is your working out. And what we're doing is making sure that we've grabbed those key dates and those key items, and we've just really condensed it all. So we're not now looking at all of the fluff in the question. We've condensed it and we're looking at the timeline. So we know that on the 12th of June, the quote was submitted by Classy and it was submitted by courier, valid for 6 months, which would take us to approximately December 2013. And we have a 5% performance bond as a condition. Those are the key items. Then we know that on the 27th of November, View mails Classy accepting the quote with amendment to terms. So now we want a 10% bond as a condition. On the 28th of November, Classy sends a letter to View revoking the quote. This is within the 6 month period still. Then on the 29th of December, both the letter revoking the quote and the letter accepting the quote with the amendment arrives at Classy's office. So we've taken what was in not the correct order and now placed it in the timeline from which it happened. So we're going to move on to IRAC. Now, in certain law school subjects, you'll be required to regurgitate some of the facts. However, in really short problem questions like the one that we have on screen, that's not necessary. So we're going to first off write our IRAC, which is what we've looked at previously, and there's a couple of videos on that if you're unsure. So IRAC is issue, rules, applications. That's not how you spell rules, is it? Application and conclusion. And what here we are looking at is how we're going to respond to the problem question. I like to put rules and application together. However, this is up to you. And for a problem question like this, it kind of makes sense. But for some problem questions, it won't. I'm going to keep these as headings for now. However, it's up to you, and check with your university and your lecturer whether you should be keeping the headings in or taking the headings out when you submit your assignment or tutorial question. So the first question we're going to ask is, well, what is the issue? What are we actually responding to? And here we know that the issue is, has a legally, we won't say binding, let's use the exact same words. Has a legally valid contract been entered into between View? Actually, let's keep it exactly the same. So see how there's this temptation to put things in your own words for the issue. When it's given to us so succinctly, we should just use those words. So does a legally valid contract exist between View and Classy Roofs? Short, sharp, shiny. For a tutorial question, that's all we need. Don't overcomplicate it. Then we're going to move to rules and applications. Now, obviously, what we're looking at here is contracts. So we know we need offer, we need acceptance. So let's have a look first. Again, this can be off on our little cheat sheet paper. Do we have an offer? Well, hang on. Classy Roofs quote is an offer. So we know we have that. Okay. But do we have acceptance? Well, hang on a second. The Classy Roofs quote, it was actually revoked on the 29th of November when the letter arrived at the offices. So here we know, okay, so we've gone through, well, we don't necessarily know, has it been accepted? Geez, this is a tricky one. So now what we're going to do is we're going to look at the rules and application section. And here is when we're going to start using either, and this is just a note for students, you wouldn't put this in your actual tutorial, but this should be either case law or legislation as applicable. So what we are not quoting here under the rules and application is things like your textbook, lecture notes, podcasts, YouTube. We're not using that under rules and application. You might use that in your discussion of the issues or to help with your understanding in more complex problems. But for a short tutorial question such as this, if it was marked, the lecturer is not looking for textbook, lecture notes, podcasts, etc. For the rules to be legally binding, it needs to be case law as legislation, case law or legislation, sorry. And sometimes there won't be legislation that's applicable, particularly in the instance of construction contracts. However, sometimes there will. So what we're going to do here is then, put this part here into some nicer words. So we would not be using dot points, but for the purposes of drafting your assignment or your problem question, I would write, let's use capitals, Classy Ruth's quote is an offer. Then I would also be saying something like this. When the letter arrives at due officers. What are we going to do here? We're going to look at some case law. And one of the cases we might look at, for example, is this one. And I'm grabbing this one from our class's lecture slides. However, your problem question will potentially be using case law that you've discussed in the lectures previously. So this is where it's important to look at the lecture slides and attend lectures, because often the lecturer will actually give you the case law that they're wanting you to use, or it'll be in your reading. If this was an exam question or an assignment question, we would of course be using the full citation. However, for the purposes of this video, we're going to keep it short and sharp, sorry. So here we might say something along the lines of, well, the letter sent by View on the 27th of November. See how I'm using the dates that we've grabbed from up here. At first sight, may look like a letter of acceptance. However, it is not. So this is one of the key issues. Has there been acceptance? That's however, it is not. The letter is, in fact, a counter offer, as it proposes a change in the value of the performance bond. So you can see here, because we've gone through these details here and we know, well, they originally quoted with a 5% performance bond. Yes, that quote was accepted. However, it was accepted on the premise that the performance bond be increased to 10%. And at no point in the rest of our timeline does Classy then mail back and say, okay, View, I accept the 10% performance bond as a condition, or yes, I've signed the contract with the 10% performance bond. Then we're going to say something along the lines of acceptance must be unqualified acceptance of all the terms in the offer. Here, use case law name as authority. Then we might look at, okay, well, okay, what about the counter offer? So another issue that we're going to look at is, what does the counter offer do? And another case that we might look at, and I'm just listing them up here so that you can keep track of them, but down here in these brackets is where you actually use the authority. So here, for example, if you wanted to use this particular case, you might then do something like this. However, you can use whichever case is applicable to that statement. So we're using case law in this tutorial example as authority for our statements. Another case that we might look at, which again is taken from the lecture slides, is Hyde against Wrench. And again, if this was an assignment, use the full citation. And when are we going to use this case? Well, we're going to use this case in the instance of discussing about the effect of a counter offer. So we know that the effect of a counter offer is to destroy the original offer. And again, I'm using dot points. Don't use dot points in your assignment. Here, for example, well, hang on, where did that come from? Done. That's authority. We're not making things up. The court said that before. And then we're going to, well, hang on a second, we're going to apply all of this together because we're doing rules and application. And that's why I like doing rules and application together, because you're sort of working through the issues and applying the law to those issues as you go. Therefore, the original offer no longer stands as from the 29th of November due to, then we might say something like, being effective and views counter offer. Well, something like that. Again, you'd finesse it out as you go. So then we need to conclude. And the conclusion is making sure that we bring back this question. So we were asked, does a legally valid contract exist between View and Classy Roofs? How are we going to conclude? Therefore, we don't need therefore, but add it in if you want. No legally valid contract / no legally binding contract exists between View and Classy Roof. Something like that. Short, sharp, shiny. Now, some other issues that you might have also worked through. Well, hang on a second. What if View's letter had been a valid acceptance? So that's another question that you may be asked. So if they hadn't come back with the 10%, aka no 10% variation, that's another question that you may have been asked. And when you're putting together your exam notes, it's important to go through your tutorial questions and see what other types of questions may have arisen from them and put some answers together. So another issue to potentially investigate in other questions. So it's putting a creative hat on. So what if there was no 10% variation? And also postal rule. The postal rule, battle of the forms, is a very hot topic, particularly in contracts and timelines. which is generally brought up in a contracts offer and acceptance situation. What you would then do is put this into paragraphs, and then at the very end, you would, once you've placed these into paragraphs, you would delete the issue, you would delete the rules and applications, delete the conclusion, delete your notes to yourself if they were done in the Word document, and be left with a lovely paragraph answer. Again, I've used dot points for time considerations, but always use full and proper sentences and paragraphs. You would be left with your answer. However, you've broken it down and it flows really well. Hope this has been helpful. If you've got any other questions, please do not hesitate to ask. Thank you.